Hello, my name is Joseph Rory and I'm with the Marion C School of Common Law. You can find us on Facebook under the Marion C School of Common Law, and we have classes every Friday night. We also have archives for the classes that you've missed. So, you think you've had a jury. This is what this is about. You're wanting to collect $1,000. Well, I'm willing to pay it if you can prove you had a jury trial. We're going to go over what a jury is, and you're going to know before this is over that no one is getting a jury trial in the United States anymore. I'm not aware of anybody that's getting any. We've got panels that they call a jury, but let's face it, it's got to be a jury, not just called one. So what we're going to do is we're going to educate you. As Marion C. Metz used to always say, a person educated wrong is worse off than a person not educated at all. So we're going to go over the juries. This is a 1681 pamphlet printed for the purpose of defense of getting juries in order and right, and defying the king's way of doing things. And in this pamphlet here, there are certain elements that has already been put together. 1681, we were pretty much still developing the jury system, but it was getting completed. There's no doubt about by the time it landed in our Constitution what it meant. But by this time here, we're going to find out that juries, as his defense was, and we'll just go ahead and read this first statement of what this pamphlet is about. Give you an idea here. Reasons why the court can neither fine or imprison juries, and for delivering a verdict according to law and their conscience. Two things that he's wanting to cover is basically some jury elements where they ought to be. He wants to also cover the fact that a jury should not be fined for a particular verdicts that they've came with that's in defiance of the king or against the king's will. 6 things that he wants to complain about immediately. Pamphlet, we're not going to cover the entire pamphlet, but we are going to get into what the main course of this is about. One, an element that we need to understand is it says that one is that juries must be in number of 12 at least. Now at this point in history, the actual 12 has not been established to be the absolute number. What they did do, there was juries that had 4 knights and the 12 men. And this is not really going to go over too well when you got 4 knights. You know what they represent, the king. And they're not exactly the right thing to be on the jury, so you had there 16 jurors, as they would call them. Now the elements that were there was not necessarily the same as what eventually got put in there in a more of an impact. But these arguments from this pamphlet here, I believe pretty much did instigate it to get further into place of the intent. The pamphlet here, juries, the power and privilege of juries asserted in opposition to the willfully blind and malicious humor of some uncharitable men, okay, ill and uncharitable men. And it's the idea of juries. What is a jury? In other words, if you want to collect your 1,000, we got to know that it was a jury that you was on, if you was even on one or had one in a trial. Those that think they've ever served as a juror, not by law you have not, and not by truth you have not, and there's no way that whatever you served on and they called you was you a juror. And if you claimed and told a judge in any defense of yours that you demand a jury trial, by the time you get through with this, you're going to know you did not get one. Okay? Because what is a jury? It's not just, can we get together and say, so many men here, we're going to put it in their hands and let them say it today, and whatever elements is in them, it doesn't matter versus the elements of the past. It's just that we selected you 12 people out of the community somewhere or another, and there's your jury. If that's all it is, we don't even need them. Okay, there's no such thing as having just anybody selected out there, especially the brainwashed people today. But we don't want them. So what we are going to do is study what a jury is, the elements that we're looking for. So the first thing he said was the jury, 12 at least. And this was definitely a very established number. And so it did, within just a few more years, just 12, 12, 12, 12 got on there so much that that common law insisted it was the 12, and it was remained the 12. And to this day, it still must be 12. And the reason why is because it was 12 when the word landed in your Constitution. Now you have a state constitution and you have a federal constitution. The state constitutions had their term jury, and whatever jury meant, the elements and what they expected a jury to be, is exactly what it has to be today. There is no amendments to change that. And the very states that used the word jury in their constitution had a convention to ratify a federal constitution, delegate some powers to it, not give their powers up, but delegate some powers to it, and to and some of it was about juries. So the word jury, what was it at the time that it landed in our law? Okay, our law, the law of the land. The second was the quality, for quality, in other words, you want quality in the people. And they had to be liberae, legis homes, which means they were men of just, they wasn't outlaw, they wasn't convicts, and they weren't perjurers and etc. They were men of morality, good standing. Alrighty? And that's the importance that we've got to understand. We've got to first get sound people. Then we have number 3, the pamphlet argued, they must be men of substance and estate. You have to have property. That's been known throughout the common law. There's no rights unless you have property. There's no voting power that would be worth your vote if you don't own property in order to make your vote mean anything. You know, a person without property, what business do they have voting on taxes when the only one that's going to be paying it is those that has property to pay that tax? And so it would be easy for someone to say, yeah, you can go up on property taxes, you can go up and have property taxes for that matters. And you can have watch taxes, and you can have pencil taxes, and you can have jelly bean taxes, and you can have liquor taxes, and you can have blinking your eye taxes, and you can have combing your hair taxes, and you can have looking through Alice in Wonderland taxes. It doesn't matter, it can go on and on. The word tax is definitely an unlimited word that gets used quite a bit. Well, the point is that you had to have property, and that was also to be on the jury. You must own something. The reason why, you got something to lose. Now, if you don't have the morals to protect your neighbor from sins and corruptions, you definitely are going to protect your own property, and you're not going to let somebody get convicted and their property taken, meaning that when the time comes they want to take yours, guess what? They're going to vote against you too, and then you'll lose yours. So it's important that you have some value to you. You've got moral value and, of course, property value. But man of substance, okay? So that's what we're looking for here. Now, in the jurors today, as they want to call it, and of course we have to redefine it and give them a different whole description of what they are. They come from some computer spit out of some driver's license list, and they don't know anything but to follow the government. If they have a driver's license, that's proof that they just believe that the government's power is right there to make them have a license to actually travel around in their own vehicle. And there definitely can't be much to that, okay? So let's look at the fact that we have that they must be men of substance. They must be summoned out of the neighborhood. Now that's important because, you know, this driver's license deal where you are given the idea of the some wild across the county type driver's license or social security numbers or whatever they want to use these days. I think most states are stuck on the driver's license as if that would have something to do with pulling out righteous people, men of substance, men of morality. You know, this is not going to work. Okay, and then let's look at it this way. Suppose you're resisting the driver's license, that you just don't think that that's right, and that God gives you a right to travel, and you don't need to ask permission to do something as simple as go to the store in your vehicle. I don't care what you call it, it's yours, okay? Wordplay, I know they play with it, and they will use the word driver. Of course, the word driver means something as well. But let's face it, if you're on the jury and you have a driver's license, and someone is saying, I don't need a driver's license, well, first of all, you're not even his peer. I mean, first of all, mentality you're not. You're believing it's the law. And you're definitely not going to go against him. You're already a biased juror to begin with, if all the other elements are there. So, you know, getting outside of that and moving on, you're going to need to understand what does make up a jury and their power. So what the power is that they can nullify the law. We'll get to that in just a second when we get to Blackstone. Because right now we're in 1681 with the pamphlet in defense of juries and what they ought to be. So in the neighborhood, by the way, is they only had they had their hundreds, and that whatever they did among themselves was never interfered with by any of the sheriffs or the people that were in office. And think of how little and how less of office holders there was in those days, and was definitely unnecessary. A lot of this stuff will take videos on other subjects to really explain. So I'm going to try to be short with this because we're going to get to the jury here. We have to understand that. And so what we're doing here is they had to be drawn out of the neighborhood. Now, you might accidentally get somebody out of your neighborhood, accidentally, through the system they use today. But they're not going straight to your neighborhood to get to 12. Not only that, they're not going to be using the sheriff with his writ. Jurors were drawn by writ. He argued that jurors was by writ. That's what's called due process. Due process means due process or due writ. The proper writ. Jurors today, they don't have a writ. Where does the sheriff has his writ? When does the sheriff ever even collect the jurors anymore? And so we already know that the elements are missing there. Too many elements and it's no longer what it is. You can pluck a leaf off of a tree and it's still a tree. You can pluck 10 leaves and it's still a tree. You start pulling the limbs off and it's still a tree. You might not have any limbs on it and it's still tall and up there real high and alive, and you might still say it's a tree. But now once you cut it down to where hardly anything but a stump is left, you're not going to call that a tree anymore. You're going to say, well, that was a tree. And this is what you're going to be saying about the jury when we get through with it. What you're saying today, you will see that was a jury until it is this, and no longer is it a jury anymore. But they're going to operate this stump as if it's the tree. They're going to operate this depleted jury with hardly any elements left and say it's the jury that you're supposed to get. Okay, so the neighborhood, for instance, the 100 people never even left their community to seek any kind of sheriff's help until there was a crime, and that's got to be properly defined too. By the way, we're going to find out about the dictionary conspiracy, where they actually redefined all kinds of words after 1864, in 64, 1863 and back. The word jury had a good strict definition and had an element in it that's no longer in it. You've got the word Congress, federal, and etc. There's plenty of words that they actually falsified. so that you would never know the truth of the past. And most of you don't. And this is going to be brand new stuff to you. Some of you is probably thinking, what kind of junk has this guy got now? We're hearing all kinds of mess these days. Yes? Yeah, you're going to have to pull me there until you research it yourself. You're going to have to just throw me into the pile of everybody else that's got something to say. But we're going to find out the truth here, and this is what we're about. So the sheriff, would only come in and arrest the person that committed the crime, say it's murder, and he would have to then get through the court a writ to get the jury at a certain time. And he would go and get 48 out of the neighborhood. Now there appear to be some exceptions, a little bit, that appeared that the county would be of somewhat possible, but these exceptions may not be the rule, and that's where we're at right now. The descriptions of jurors through Blackstone and this pamphlet and the Constitutionalist people, they always ruled it as a neighborhood. They use the term neighborhood, and you need to understand what a neighborhood is and why it's more centered. Idea is to get more close to home to you. You're accused, you need to be home. You need your people to put you away or keep you. And so the common law is not like statutory law where it says a certain way, so you're guilty because you violated the particular statements. Okay, it's not like that. So then the next thing that he brings up is that they are sworn to find according to the evidence. Now this is one of the elements that's left, and that's sort of again like the stump that's left, the stump. And so it's left. The jury still get to go by the facts of the evidence. And then they may be challenged by a poll or array. And it's the challenges that you want to understand the rights of a juror is whether you can challenge them. Now, in today's courts, and we're going to get into Blackstone because he's more vivid about these statements, and we're going to, if you don't know who William Blackstone is, he was the actual law of the land commentator. If you wanted to understand the common law, you accepted Blackstone. Our forefathers accepted Blackstone. If you was a lawyer in those days at all, if you argued before any court, real court of course, you argued Blackstone. If you was a lawyer, you had Blackstone, 4 volumes of Blackstone. And that was your completion and understanding. You'd go to court with Blackstone, and you would quote Blackstone and prove that the common law is this, and the law is this, and the law is that. It is not this, it is that, according to Blackstone. So we're going to understand Blackstone here. So Blackstone comes along, and he starts giving the causes of challenging jurors. And of course, if they're not from the neighborhood, Blackstone used the term neighborhood, if they're not from the neighborhood, they can be dismissed, or you can even call it a mistrial if you found out that after the verdict, any single juror was from another neighborhood. It's out. Okay? Now, you've got Blackstone. Let's go over some elements that he said. They could be witnesses to the facts. In other words, you was all in a bar. John hits Mark. Mark falls down, hits his head, and dies. A sister of Mark jumps up and accuses John of just outright murdering him, and the sheriff has to come in and arrest him, and he's on trial. Okay. Now you was there, and you said, well, look, I remember when John was being threatened, and not only was he being threatened, but Mark raised his fist with the threat. John hits Mark. Mark hits the floor or the table and dies. Okay? Now, this juror could be a witness. You're not dismissed because you know something about the case. But what do they do today? Think about the elements they are destroying, totally wiping out, keeping a jury like zombies some brainless people that has peanut butter smeared in their skull, and that's it. That's it. They got. That's what they got for brains. Something just smeared up there, gray matter. It says, "Hey, brains." A note that says, "Hey, my name is Bob." You know, I'm serious. I hate to be that sarcastic, but in one sense, sarcasm has a point. It's one of the best ways to drive a point. But you know, a juror is being totally diminished to know anything. That what they want today is they want a juror to absolutely have zero knowledge, and let the lawyers battle on who will get to the jurors or not. That's not justice, and it's not even a proper way to think on obtaining justice. You know, the best lawyer wins. That's pretty much the case. If a lawyer sleeps on the job and he's just not objecting to the right stuff, he's not even knowing the laws of Blackstone, he's not even caring about the common law, he's got nothing but statutory law in his head, and he thinks that statutory law is just as powerful as common law, and so this person right here just gets burnt because he's not even caring, and he might care if he knew, but he just doesn't know. So we have a problem. Is that the jurors are being totally wiped out of any possible power they have. Is one, the power of actual knowledge to the case themselves. They were actually witnesses, and they're thrown out because they already know something. Or they heard a rumor. There was a TV spot that they heard. And as if, oh, now you're contaminated. There's no way you'll ever be able to sort out the truth now because somebody threw a rumor in through the television. Or you read a newspaper article. Oh, no. You know, this is not the problem in a juror of our past. You're supposed to be what? We've already set up that you're a man of quality. You've got morals. You're not a criminal. You're not doing things against the law of the land. You're not an outlaw. And so when you have a state and etc., this is the idea. So now we're going to look at the fact that you can even know the person that is being, according to Blackstone, you can even know the person that's being accused and be on that juror. You can, you have to be out of the neighborhood, and you can actually even be kin as long as it's in the 9th degree. So think of what we're doing here to what they call the jury system. And we want to let you know that Blackstone also made it clear that one of the elements of the jury, which they totally wipe out today, of course the others is totally wiped out as well, but with a little more emphasis to the one that would probably be the greatest, is the power to judge the law and the facts. According to Blackstone, the jury was able to do that. Okay? If you take away that, then you've taken away a major element. And you take away this other element, you've taken away another and another and another. Just like the leaf illustration a while ago. You keep taking enough leaves off, the limbs, and finally the trunk, you don't have a tree anymore. And at this point, we don't have juries anymore, simply because everything has been taken away from what they are. But the name, jury, still sticks. Think about it. Now, Noah Webster defined the jury, and in his description, he covered some of these elements. He didn't get them all, but he still covered some of them. But one of the things he did cover was the fact that he had a right to judge the law and the facts. In other words, jury nullification is a term that people use for that. Now, if you got the power to do that, that's going to keep the government sort of a little bit eased down on how much they're going to pass. We're going to realize that the juries will never really go for this one. All right? Because if you're going to always be able to check them, remember the check and balance system? That jury system is a very good check against the government. Get it right, you'll have a big check against them. So you deplete the government of its so-called depleting powers because they don't have the power to deplete juries and then sit there and throw a panel of nobodies that is totally without all the powers that a jury is. And so if you take the powers of a fish to swim out of them, I don't know what you might still want to call him a fish, I don't know, but he's not going to make it. It's not really worth being there laying around just letting the wind blow them around. And of course there are certain animals in there that actually just floats with the waves. But we're talking about a fish, and if he starts taking your fins, the scales, and before it's over with, he's not even able to swim, and he's just a skeleton now, you even took his meat off of him, what is he? Okay, it's gone. So the juries today don't exist, but in the Webster's Dictionary before 1864, it always stated that they had the power to judge the law and the facts. Now in 1864, go to my videos on the Dictionary of Conspiracy, you'll see that that was the edition that Noah Porter used to destroy America through lexicography, redefining words like federal, state, Congress, united, unity, alliance, democracy, republic, liberty, jury. All these things were depleted and gone, and in some cases reversed in power and meaning. And this is why we are where we're at today with the idea that there is no juries today. Not by elements and not by nothing but by name. And you can call an elephant a hedgehog if you want to. But it's not a hedgehog, no matter how many times and how many people. And if the Supreme Court calls them a hedgehog, if the president, if the entire Congress, if the legislatures of every state wants to get together and call an elephant a hedgehog, guess what? He's still not a hedgehog. There's just powers they just don't have, and this is where we've got to stop this. So you want to collect. Well, then let's see if anybody has ever had a jury trial that one, the judge didn't tell them to not know the person. Like, is anybody in here knows the defendant? If so, raise your hand. And if someone raised their hand, okay, you're dismissed by. The second one is that if you heard anything about the case or whatever, you're out. All right, these are things that are wiping out something you're supposed to be able to do, and they're never going to tell you your power to nullify. And so, you know, the juries are just like the king, and that was the whole idea of this pamphlet here being published, is that the king was known to want to punish some of the jurors for their decisions. And you know, if you're going to make an oath and to God Almighty, and we're talking about a real oath to God Himself, not the words that people say and they don't know, they don't care, but we're talking about a real oath, and your conscience is now set with a oath to do this thing right, and yet at the end of your oath and at the end of all your decisions, you're going to do what the king said. Then your oath is useless anyway, and you definitely defied God. I mean, your conscience is not there. Let's face it, you don't have one if you can make an oath to God and then do what the judge tells you to do. That's his decision. If the king comes in and makes the decision for you, that's his decision regardless of whether you made an oath. And that was one of the arguments he made, that it's against the law. Here, we'll just read that section right here. He says right here, it goes, because such commitment being without process and judicial trial is against law. And he quotes the Magna Carta. And he says that it just kills the entire institution, period. Why? Because the institution of it, well, one of his arguments here is it overthrows the juries and all the solemnity in repairing them. He claims, of course, that if you're going to go all through all the trouble to get a jury, and then yet you're going to end up telling them what they're to actually give the verdict to, you've wasted everything, the jurors and all. So, you know, when we're looking at this, we want to understand that the power of the jury, if it's not in there, and the power to swim is not in the fish, the leaves and the limbs and the entire trunk is gone from the tree, and all these elements have gone from the jury, what do you have? You do not have a jury. So you don't have a jury. You can claim it all you want, you can name it all you want, but it's not a jury. And we at Marion C. School of Common Law, we teach the true common law, and we want you to understand that. So I want you to meet us on Facebook and look under the Marion C. School of Common Law. You can also email me at dueprocessrequired@gmail.com. And you will find more up, and there's plenty of very intelligent people on that site that, you know, I consider myself second to. I mean, there's plenty of them. I might even be third to them, for that matter, fourth. But we have some very intelligent people on the Marion C. School of Common Law. and those that are learning. And that's what it's about, learning. Remember, a person educated wrong is worse off than a person not educated at all. So what we're wanting you to understand now is, did you get a jury trial when you look at what a jury really is and not what you've been told? Especially through the lexicography, where all the dictionaries, including your blacks and these dictionaries that's supposed to be the law dictionaries, you do not have them, so don't think you have one. So until Shiloh come, this is Joseph Roy. Thank you.